Can you send a debt validation letter when you get sued by a debt collector like Midland, Cavalry, Portfolio, or LVNV? My name is Michael Wasylik. I'm one of the lawyers at Ricardo and Wasylik here in Florida, and together with my partner, Jason Ricardo, I help people just like you overcome debt collection with dignity. And today I'm going to tell you whether you can send a debt validation letter when you get sued by a debt collector or a junk debt buyer like Midland, like Portfolio, like Cavalry, like LVNV. So let's dive in. And as we begin the video, go ahead and drop down to the comment section and tell us if you're being sued by a debt collector, what state are you in, who is suing you, how much they're suing you for, and what, if anything, you've already done to respond to that lawsuit. We do our best to answer every comment we get either in the comment section below or in a video just like this one. One of the most common questions we get in the comments is, if a debt collector sues me, can I still send a debt validation letter? And the answer is yes, and there are 4 reasons you might want to do this. Under the FDCPA, the Fair Debt Collection Practices Act, specifically subsection 1692G, a debt collector has to give you notice of your right to request debt validation, and when you take them up on that, when you actually send a dispute into a debt collector in response to that notice, you have certain rights. And those rights still exist even if you're in the middle of a lawsuit, especially the closer you are to the beginning. Let me explain. 1692G says that you have 30 days from the time you receive the disclosure from the debt collector to send your response, which may include a dispute and a request for specific information. And if you've watched other videos on the channel, you'll know all about that. I'm going to leave a link in the description below to some of those other videos where we talk about the debt validation form, what you can ask for, what you can expect to get. But in the meantime, I'm going to talk about how you want to use this in a lawsuit if you're going to. In many cases, the debt collector will attach that disclosure notice to the lawsuit itself because in many cases, that's the first time the debt collector has reached out to the borrower about the debt that's in dispute. And if you respond within 30 days, you get certain rights. Number 1, if you send a written dispute to a debt collector saying that you dispute the debt, whether it's owed, the amount of the debt, or anything else about the debt, their entitlement to collect. If you have a dispute about the debt, they must stop collection until they provide you so-called verification of the debt. Now, verification, if you watch our other videos, you know this is a fairly low bar. All they have to do is provide some documentation of what the debt is, the amount, and the person that they're trying to collect from. And until they give you this information, they have to stop all collection activities, including they have to stop moving forward on the lawsuit itself. They can't ask the court to enter a judgment against you. They can't ask the court to do anything negative until they have provided you the information required by law. So the first reason you might want to send a debt validation request in response to a lawsuit is because it might give you some breathing room. It might give you some extra time to help you fight and beat the lawsuit that's been filed against you. Now, the second reason you might want to send a debt validation letter in response to a lawsuit is because if you are sending that within 30 days of receiving the G notice, the disclosure that might be attached to the lawsuit, they do have to send you that validation information. Now, again, there's no definition of what they're required to send you, but many cases, a debt collector will send you more information than is attached to the lawsuit itself. Some debt collectors, in response to a debt validation letter, will actually send you many months worth of statements, and you can use this information to undermine their claim. For example, there's one debt collector we deal with on a regular basis, a junk debt buyer, that routinely responds to debt validation letters by sending copies of every monthly statement that they have in their possession regarding the account. And that can be 2 years or even more. And what we found by looking through those statements, we found ways in which that debt collector is wrong about the amounts they're claiming, the dates they're reporting, and other critical information that helps us not only defend the lawsuit, but also attack their false and improper credit reporting. So even though they're not required to give you a whole bunch of information, there's no way for you to force them to give you specific information in response to a debt validation letter. Many debt collectors will give you more information than the law requires them to give, and you can use that information against them. So that's reason number 2 that you might want to send a debt validation letter. So what if you're beyond the 30 days? What if the 30 days has already passed by the time you decide you might want to send a debt validation request? Can you still send the letter? And does it make sense for you to send the letter even if you can? The answer to both of those questions is yes, and there are two reasons why it might benefit you to do so. Now, if you're beyond the 30-day window, it won't automatically stop the collection efforts, which means that they don't have a real incentive to give you information in response to that, but it does do two very important things. Number one is that by sending them a debt validation request, you are telling them you dispute the debt. And in fact, if you're using the forms that we've talked about in some of our other videos, you'll know that there's a box you can check that says, I dispute this debt, along with selecting a particular reason. Why does it benefit you to have that dispute on record? There are two reasons. In some cases, the absence of a dispute can be used to create a presumption that the amount they're seeking is correct. In other words, if you received a statement and never objected to it, under the law, there's a claim called account stated, which says if there's no objection to the account, then it's presumed to be correct in the absence of other evidence. But if you dispute it and you say, listen, this is the first I'm hearing about it, now that I know about this debt, I am now disputing it, you are putting on record that you disputed it at the earliest opportunity. And the second reason a dispute benefits you is that no matter when you dispute the debt, no matter when you send your debt validation request, as long as it says that you're disputing the debt collector then has a duty under federal law to avoid reporting it on your credit report unless they also report it as disputed. In other words, if it shows up in your credit report and it doesn't say it's disputed, they're breaking the law. And when they break the law, you can sue them. And when you sue them, you can get $1,000, $2,000, sometimes even more if there's actual damages, along with attorney's fees and the like. And the amounts of money that they will end up owing you are often enough to wipe out your debt entirely. So those are the two reasons why informing them of a dispute is in your interest. Now, the second way that sending a debt validation letter in response to a lawsuit can benefit you is that you can use that letter to notify them if you already have a lawyer. Because once you have a lawyer, their lawyer's on notice, and it's illegal for them to contact you. It's a violation of the FDCPA, and it's also a violation of Florida law for them to reach out to you directly, for them to communicate with you directly if they know you have a lawyer. And it's also a problem for the lawyers on the other side. Once they know a lawyer is involved in the case, once they know a party has representation, they are barred by the rules of ethics that govern all lawyers. They're not allowed to reach out to a represented party without permission of the lawyer. So federal law, state law, and even the rules of ethics that govern Florida lawyers all combine to prohibit them from reaching out directly to a consumer, to a defendant in a debt collection lawsuit. So we see debt collectors break this rule. And how do we respond when a debt collector breaks the law regarding direct communications with a represented party? We sue the debt collector. We end up putting money in our clients' pockets as well as getting their legal representation paid for by the other side. So they walk away not having paid a dime, wiping out the debt, and even making a profit, because when a debt collector breaks the law, that's an opportunity for you to get rid of the debt forever and maybe even put money in your pocket. That last bit, by the way, is why hiring a lawyer to help you out with a debt collection lawsuit may actually make you money instead of costing you money. So consider that. Before I tell you your next step, go ahead and drop a like on this video if it's been helpful for you. It lets me know you want more like this. And share it using the share button if you know somebody who needs to hear this information, if you know somebody who's been sued by a debt collector. But if you have questions about how to use a debt validation request, if you have questions about what form the letter should take, if you have questions about how to use a debt collector, go ahead and watch the video I'm going to put up on the screen now. It has all the information you need to use debt validation in your favor, whether it's in the middle of a lawsuit or whether it's early on in the process, if you just have information appearing on your credit report, or if you have gotten communications from debt collectors. Using a debt validation letter can be a powerful tool, and the video I've got on the screen now helps explain it all. So thanks for watching. I'll see you on the next one.